Right now, will the High Court rule to allow same-sex marriage? We're going to try to read the tea leaves. And next, Stop and Frisk on trial. We'll take you live to the courtroom in Lower Manhattan for the very latest. And later, March Madness. Well, we all love college hoops this time of the year, but the question is, could a lawsuit making its way through the courts right now change all that? Hello, everybody, and good evening to RFL. I'm Richard French. Thanks so much for joining us this Wednesday evening, March 27th. A lot to get to in the next 60 minutes, but we start where we began last night. For the second straight day, the Supreme Court addressed the issue of same-sex marriage, and today they heard arguments on the law that says that marriage is defined as a union between a man and a woman only. Now, senior political correspondent Andrew Whitman, he's been following the case all day. He joins us with more. And I know, Andrew, we'll go into what happened, but also you see these conflicted justices and you start to ask, why did they take the case in the first place if they were so unsure as to whether or not they should even hear it?
And there may have been some justices asking that very question today, Rich. If you're in the business of reading the tea leaves, today made for some interesting listening. Several of the Supreme Court justices questioned the constitutionality of the Defense of Marriage Act, and they wondered aloud whether or not it creates unequal classes of married couples. At the center of it all was the plaintiff, Edie Windsor of New York.
Today, 83-year-old Edie Windsor took her fight for marriage equality to the Supreme Court.
Today is like a spectacular event for me. I mean, it's a lifetime kind of event.
Windsor and her wife, Thea Spire, were married for 3 years, partners for more than 40. When Spire passed away, she was hit with a $360,000 federal estate tax bill, money she would not have had to pay if she'd been married to a man.
In the midst of my grief, I realized that the federal government was treating us as strangers.
The Defense of Marriage Act, or DOMA, defines marriage as a union between a man and a woman, so gays and lesbians who are legally wed in their states can't get the same benefits afforded to heterosexuals. A majority of the 9 justices on the court seemed highly skeptical of the law. Justice Anthony Kennedy and the 4 liberals on the court raised questions.
And so you were really diminishing what the state has said is marriage. You're saying, no, state, there are 2 kinds of marriages, the full marriage and then the sort of skim milk marriage.
Supporters of the law argue it allows the federal government to stay out of states' experiments with marriage. The Obama administration provides no legal defense for the Defense of Marriage Act, and lower courts have ruled it unconstitutional. To try and force the administration's hands, House Republicans filed suit, but the High Court says that may not have been lawful.
It's not unusual, it's totally unprecedented.
Across the country, many people, including politicians, are expressing their support for same-sex marriage. Since Sunday, at least 6 U.S. senators have announced they've changed their minds on the issue. Rich?
All right, Andrew, thank you very much. Let's bring in our panel on this. Brandon Bryce, Republican strategist and columnist at the Washington Times, joined us, as is Mark Furnish, who was here with us last night, criminal defense attorney who's argued before the Supreme Court. He's also a professor at Brooklyn Law. Alan Drexel joins us. He's a family law attorney who's focused much of his practice on the issues that are specific to the LGBT population, and he's a co-chair of the New York State Bar Association Marriage Equality Committee. And I actually didn't stumble over that. That was a minor miracle on my part. Andrew, as we've already met. Okay, Mark. I can make a profession out of reading the court wrong here, but we talked about this last night. They seemed conflicted, they kvetched about whether this was the right place to even hear this, why they're getting in the first place. I think someone had to remind them that they chose to hear this, or at least 4 of them did. Read the tea leaves today, between today and yesterday, and I know it's difficult not to conflate the two, but I guess start with DOMA. What were they saying today, and did you take any major takeaways from it?
Yeah, I don't think DOMA is going to stand. I actually think in many ways this is a much easier case than yesterday's case for the reasons that we discussed last night. Traditionally, states have been free to define marriage in the way that they want, and the federal government typically adopts the state's definitions, and DOMA doesn't do that. It adopts a uniform federal definition of marriage that in some ways abrogates the definitions of the states like ours that permit same-sex unions. So I don't think DOMA is going to stand, and the more interesting question is the way that they strike it down. Do they say that it encroaches on and burdens state prerogatives to define marriages in the way that they want, or do they make a broader, more sweeping ruling that says it violates equal protection and this is a suspect classification and it's unfair discrimination against gaze.
To the layman, Mark,
Yeah.
if they redefine what marriage is, and even if they don't use that exact language, does it then not become a state issue all over again? Or inevitably, do states get to make up 50 different sets of rules who does and doesn't get to get married?
Well, I don't think they're going to redefine what it is. It's my instinct that they're going to take some sort of middle incremental ground, which is how they usually do things and how change usually occurs socially and at the court. And it's my strong feeling about DOMA, or my strong suspicion, that they'll say, leave this to the states to develop and don't meddle where you don't belong. I don't expect there to be some sweeping ruling that there's an unfettered right to same-sex marriage, not at this point. As we talked about last night, this has progressed very, very rapidly, and I think more rapidly than the court is usually comfortable with.
Alan, help put a human face in this, because I saw a justice yesterday, and I know it wasn't DOMA, but it was the broader issue to say, hey, listen, marriage is just a label or a brand here. In the end, a civil union, it's about the same thing. It's people just fighting for a word. You deal with people who come in your office to whom it's more than just a word, and it's not just symbolism, is it?
Absolutely not. And in fact, the case today before the Supreme Court, which challenges the Federal Defense of Marriage Act, really highlights why. The whole structure of marriage recognition by the federal government assumes that certain rights and responsibilities will be conferred on the basis of not civil union status, not domestic partnership status, marital status. And so you wouldn't even have the possibility of federal rights now emerging for gay and lesbian couples who marry after today's argument in the Supreme Court if you didn't have that right to marriage. Because the federal framework...
Somebody at home who says, hey, Alan, you know, it's civil union marriage, it's the same thing. Tell them why it's not. And it's not just the ceremony, it's not just the ring on the finger. Tell them what legal distinctions carries between the two and why somebody in New York has more rights than somebody living in Arkansas, a same-sex couple.
Absolutely. Well, I actually, in connection with work I did with the New York City Bar Association, documented 1,324 state rights and responsibilities that extend to citizens and residents of the state of New York solely on the basis of their marital status.
Give me the biggies.
Well, if I may, let me talk about the federal level for just a minute, because this was the focus of today's arguments. Social Security survivor benefits, veterans survivor benefits, the ability, and this is something that's been in the news a lot lately, to sponsor your loved one, your spouse, for a green card, the ability to receive timely notification of the death of a spouse who happens to be a service member killed in combat. These are really, really profound things, and Justice Ginsburg highlighted that today. She said, this is not trivial stuff. These federal rights we're talking about are pervasive in people's lives.
Yep.
And if I may, just one last thing. Justice Kennedy has said something twice, once yesterday in the context of the Prop 8 challenge, and once today in the context of the DOMA challenge, and that is, what about the children?
Yeah, 40,000.
40,000 approximately in the state of New York. Their ability or inability to go to school among their classmates and say, you know, my parents raised me as spouses. My parents are married. Their inability to do that. That is what the technical term is a cognizable injury. That's harmful. That hurts kids, and the court's concerned, and he's the swing vote. So I think I agree that it's very likely we'll see DOMA fall.
And Brandon, give me, if I could, bring Brandon really on this. Give me an argument why you hope DOMA stands.
Well, here's the thing. I think America is changing, and I think we have to be relevant and actually understand that you know, the gay and lesbian movement has been incredibly strong in the last 5 years. They've made extensive progress. I think here's a couple of things. I think it's less, believe it or not, it's less about the GLBT issue, and it's more about, is this a state's right? And do states have the right? And is the federal government overreaching their boundaries? And then going on top of that, looking at the benefits associated with these couples. I think that's the big issue here that I even think Justice Ginsburg is saying is that, you know, besides two men or two women or a man and a woman, we've got to look at the Social Security benefits. We got to look at, is the federal government at a $16 trillion deficit? Can we even afford to move this area further?
But you know, the court before hasn't looked at the bottom line when they said, wait a minute, blacks and whites should be able to marry.
Exactly.
And they've done that, okay? if we decided that racial components shouldn't decide who gets to marry, and now we're starting to see, and they're looking at the public pulse here, and even notable Republican lawmakers were talking about Rob Portman giving, I think, the most compelling argument, which is government shouldn't be in the business of going into people's bedrooms.
I certainly agree. Yep.
Then why hasn't the court said that if we're deeming people to have equal rights, we shouldn't be looking at the cost of, let's say, Social Security benefits as a factor in deciding if they're equal under the eyes of the law?
Well, and I actually think that's the downfall, is that I think when you take it away from the economic issues and the economic measures, and you solely focus, is this right or moral, I think that's where you have a fundamental challenge. I can tell you right now, the evangelicals are up in a storm about this issue, but I think from an effective measure, you can sell the message of DOMA or not DOMA when you talk about, can we afford to move on this legislation, and is it actually cost efficient to take on another issue dealing with DOMA, when at the end of the day it should be about the federal government has no ties or business or responsibility in your bedroom or in your personal lives.
What does this cost the federal government? I mean, how's this a debt and deficit issue? What's the cost to Uncle Sam if you eliminate DOMA?
Well, because here's the issue. I think you're taking on more beneficiaries. If two people are married, you're taking on more cost-efficient measures. You're also looking at Social Security benefits going out to skyrocket, and you clearly don't have enough funding now at the federal level. And I don't think at the federal level, I don't think we can afford it, on top of the fact that it's not a federal issue. It should be an issue solely left up to the states to decide.
Here's the thing that's most visceral about it to me. Once you grant the right to civil unions and all the other accoutrements of marriage, short of marriage, you're getting into Plessy versus Ferguson area.
Exactly.
If you're saying, separate but equal. No, there is no separate but equal doctrine that's recognized or cognizable under our law. And that's what we're getting dangerously close to, and that's what the various courts around the country that have struck this down on equal protection grounds have almost uniformly said. Once you're down the road of unions, pacts as they're calling it in these arguments, civil unions, what's the justification for going the rest of the way?
Somebody who's not without a sheepskin hair, and I can say, out of every place that's passed it, I must have missed the petulance and famine and the riots the next day. Nobody even, it's a collective shrug. And we're going to look back, just like we look back in other choices, and say, like, we fought over that? Really? Okay.
Well, that's postponing the inevitable.
Yeah, I believe so. We're going to take a quick break. But when we come back, we're going to stay on this issue. And I'm going to bring Mark back in because he went before the High Court. And there's a lot of questions from people who've maybe been on the outside but not on the inside as to what exactly is going on in there and whether or not public opinion should matter here, and the relevancy of the High Court if they say it doesn't. We'll get into all that after this.